everyone. Happy New Year. Welcome you joining today's class, Eviction Moratorium, Rental Assistance, and the extension from CDC. I'm Pauline Lam from Kota Realty, your 2021 Co-Chair Education Committee. A few housekeeping tips. All participants will be muted, and should you have any questions, please enter it into the chat box. Mindy will help to address the question during the Q&A section, and speaker will answer it. So to fulfill all your questions. This meeting is being recorded and will be available on our YouTube channel, West and Gabriel Valley Realtors. Now, I would like to invite our 2021 President, Mindy Ye, to introduce our special speaker, Attorney Dennis Block. Mindy, now the floor is yours.
Thank you, Pauline. Good morning and welcome, everyone. Gives me an honor and pleasure to introduce Mr. Dennis Block. He's a founder of law firm of Dennis P. Block and Associates. His law firm spans 4 decades of representing income property owners and consists of 19 attorneys, and he has conducted over 200,000 evictions. His firm represents municipalities, the federal government, real estate management companies, and of course, mom and pop owners. He is a past president of Apartment Association and has been a radio talk show host. Mr. Block conducts numerous seminars for fellow attorneys and income property owners. Please help me welcome Mr. Dennis Block. Dennis, you have the floor. Thank you.
Thank you so much. Very nice welcome, and appreciate the opportunity to talk to the San Gabriel Valley Realtors. It's always been a privilege for me, and I have talked to your group on a few occasions. So I do welcome the opportunity to be invited back. We're in kind of unusual times. We have obviously a pandemic, which hopefully we're going to finally look at in our rear view mirror. I'm happy to tell you that I was inoculated with my first shot. So next week, then I think I'll be free and clear. So hopefully everybody out there is having an opportunity to get theirs, and we can finally wipe this pandemic off the planet, get back to our lives. I had my seminar all planned out as to what I was going to talk about. And then, of course, I'm on my way home from the office yesterday, and I realized that our wonderful governor has now changed the rules on us. So let's go over what the specific rules dealing with the Tenant Relief Act, AB 3088, and how that has now been expanded since yesterday. The Tenant Relief Act should really be called the governmental assault on income property owners, because that's exactly what it is. Unlike any other segment of society, landlords are the only one who are required to support the financial burdens of the pandemic for tenants. No other segment of society is asked to do so except for income property owners. But that's where we are faced with regard to the legislative process, and that the burden is falling directly on our shoulders. We always get into a situation with the Tenant Relief Act, which I'm going to go over, but I think I'm going to first start out by saying that part of the Tenant Relief Act requires that if there's a local municipality, that we have to listen to the laws regarding those ordinances, that those are primary. Normally, a state, when they make a law, like the quote Tenant Relief Act, then that would be the paramount law. But as part of the Tenant Relief Act, just to make everything as complicated as they wanted it to be, you have to first comply with your local statute, your local municipality. And if it's in conflict with the state, then of course the local municipality, based on the state law, controls. So let's take, for example, the city of Los Angeles. I have many clients that are saying, well, gee, the tenant has to pay 25%. And if they don't, then we can evict. Well, but that's not the case. For example, if you have property in the city of Los Angeles, you come under the authority of the mayor, Mayor Eric Garcetti, as I always like to say, may he rest in peace. And in his ordinance, his emergency rules, if the tenant in any way claims that it's COVID related as to the inability to pay rent, then on that basis, you can't serve a 15-day notice to pay rent or quit, or a 3-day notice. You can't do anything. The tenant doesn't have to pay 25%. The tenant, all he has to do is some way, somehow indicate to you that his inability to pay rent is due to the pandemic. Now, this is all in the city of Los Angeles only. Does the tenant have to show proof? No. All he has to do is tell you. And if you try to demand proof or serve notices on him, technically there's an ordinance in the city of Los Angeles which they can declare that you are harassing the tenant, and the tenant can sue you up to $10,000 plus attorney's fees. So always be in mind that you have to first realize where your property is located and whether it is impacted by that local jurisdiction before we get to the state law, which I will go over, including the new changes that our wonderful governor made just yesterday. So again, in the city of Los Angeles, you can't do anything. The issue is, well, when is the city of Los Angeles, when is that up? When is the ordinance up? So now I can at least ask for the rent. And the answer is, it's whenever Eric Garcetti, our mayor, says that the emergency is over. So until he says the emergency is over, as long as the tenant has told you that the reasons for not paying the rent were somehow, some way related to the pandemic, either wholly or partly, then you have to allow your tenant to live in your property for free. Now, when the mayor declares that the pandemic is over, then at that point, the next month's rent would be owed. So let's pretend he declares that it's over. Let's just pick a date, May 1st. At that point, May's rent, we're talking the year 2021, May's rent would be owed. And all that other rent that would be owed up to May, that rent would be deferred for 1 year. 1 year. You can imagine trying to find these tenants after 1 year, trying to locate them to sue them. So while they talk about rent deferment, the truth of the matter is that it's really rent forgiveness, because there's no way landlords are going to be able to recover this rent. It's just not going to happen. So that's the specific rules when you're dealing in the city of Los Angeles. For the San Gabriel Valley, we're dealing with really, it comes under the jurisdiction for the county of Los Angeles, because San Gabriel, for example, the city, doesn't have its own eviction moratorium. So that defaults to the county. The county's rules are similar to the city of Los Angeles. That is that the rent is deferred for 1 year from when they declare the emergency is over. However, the county made a crucial mistake in trying to protect tenants, and they had a moratorium that ended by its own terms as of September 30th. And they weren't, based on the state law, allowed to renew it. Los Angeles was just, the city was just open-ended. Los Angeles County actually had a termination date. And once that date was set, they didn't have the ability, based on the state law, to renew it. So right now, in all of LA County, where cities didn't have their own municipality, the rent is owed as of October 1st. You now jump to the state law, which I'll get into. but all rent owed in the county, like for example, the city of Redondo Beach or El Segundo or San Gabriel, all rent that was owed through September 30th is deferred for 1 year. Now I'm talking September 30th, I'm talking September 30th of the year 2020. So from October 1st forward in time until today, that rent now becomes under the auspices of the state law, which I am going to get into. So remember you have to understand whether there's a local municipality that controls the state law. If you don't have one, and I saw a question go by, for example, like in Orange County, they didn't really have any local jurisdiction. So it all defaults to the state law, which means, which we'll get into in just a second, but you're free to go forward with a type of an eviction in the, like for example, in Orange County. Okay, so now that we understand that the local municipalities control if they had their own eviction case, now let's get into AB 3088, what it means, what we have to, what the responsibilities for the tenants and the landlords are, and what just happened yesterday with regard to that. Excuse me. So with regard to the state law, AB 3088, the Tenant Relief Act, and as I call it again, the governmental assault on income property owners, they have two time periods that you have to keep in mind. That is the protected time period, and then also the transition time period. The protected time period goes from March 1st through August 31st. That's considered protected. Somebody's got to mute themselves, please. The transition time period goes from September 1, and it used to be, unfortunately, through January 31st, but that's now been extended as of yesterday through the end of June. So that now goes, believe it or not, the transition time period from September 1st, 2020 through June 30th, 2021, because our wonderful governor did elongate the transition time period. So let's go over what the differences are between the two time periods. From March 1st, 2020 through August 31st, 2020, that's considered the protected time period. So if in fact a tenant has claimed that the reasons for the inability to pay rent was due to the pandemic, then that rent is deferred. In fact, it's not even considered rent, it's considered a civil debt, and the tenant owes you that money, but you can't evict for it, not for the protected time period. You would have to bring forth a regular civil lawsuit, and you can do so as of March 1 of this year. That's coming up in about a little bit over a month from now, and you'd be able to sue for that in a civil lawsuit. Now, they have increased the jurisdictional limit of small claims court, which used to be 10,000. For this type of a debt, it's unlimited. So now everybody can go to small claims court on March 1st and sue for that rent owed during that protected time period, because there's no other basis of getting it. If the tenant doesn't pay it to you and it's owed to you as of February 1, if he doesn't pay it to you, then your only option would be to sue for it. You can't file an eviction case. You have to file a regular civil lawsuit, which you can have a firm like mine do, or a less expensive way would be to go to small claims court, and you'd be able to sue for an unlimited amount for that period of time. We are starting a program where we'll be filing small claims court. They don't allow attorneys in small claims court, but my firm, and you can check on my website, which is evict123.com, we are going to start a program for landlords where we'll take care of preparing the small claims court papers for you. We will be filing it with the court. We will then take care of serving your tenant and then giving the landlord instructions as to when to go to court and what information they'll need. So it'll be a nominal fee. So check my website in February. We're going to start a program to assist landlords in collecting this rent that is definitely owed to them, but which of course the government is making very hard to collect on that. So do check my website for that. But again, all your options are during this for the protected time period, once again from March 1st through August 31st, would be to sue for that rent in small claims court or a regular civil lawsuit, assuming the tenant doesn't just want to walk over to you with a big check and give it to you. Again, if you're in a local municipality like Los Angeles, then you can't do that. You'd have to wait 1 year from when the mayor, for example, declares that the emergency is over. And then you'd be able to bring forth, you'd be able to bring forth an eviction lawsuit or sue separately for that. But if you're under the jurisdiction of the state law, then you can bring forth a small claims court action, which is what I recommend doing, as opposed to hiring an attorney to do a somewhat expensive civil lawsuit, which can obviously come into a lot of attorney's fees at that point. Let's move over to the transition time period. The transition time period started September 1, was supposed to be over in just a few days through January 31st. And now, again, our governor, in his ultimate wisdom, has now extended that through an emergency order, which I question whether he had the right to do so in the first place, to now June 31st. So what's the difference between the protected time period and the transition time period? Well, in that time period, the tenant would have to pay 25% of the rent owed. So in either case, what you're going to do, protected time period or transition time period, you're going to serve a 15-day notice to pay rent or quit. You have to have an information sheet which goes with that 15-day notice. You have to have a declaration which the tenant can sign and send back to you. And of course, you also have to have that state law, the 1179.04, the quote of that law with that package, with the 15-day package. If the tenant is served with that 15-day notice, and let's first do the protected time period, he'll have 15 days to either pay the rent in full, which of course he won't do, or he can sign that declaration. If he signs the declaration, your only option is to file a civil lawsuit. For the transition time period, within the 15 days, the tenant now has to either pay the rent in full or sign the declaration and return it with 25% of the rent. If he doesn't do that, you can immediately bring forth an eviction based on that 25%. If the tenant does pay the 25% and returns it with the signed declaration, then in that situation, all you can do is you can't bring forth an eviction. And as to the 75% of the rent, that again just becomes a civil lawsuit, which again, you can go to small claims court or file a regular civil lawsuit. So, but again, the tenant's going to have to pay you the 25%. For the landlords who are suffering out there, my belief is that very few tenants will pay the 25%. So on that basis, you're going to be able to bring forth finally an eviction lawsuit to evict these people from the property. And I would be remiss if I didn't tell you that other than non-payment of rent, you can always bring an eviction lawsuit based on other breaches of the rental agreement. For example, if they bring in extra people or they made alterations to the premises, or if in fact there was a pet that was brought in, like a dog or a small giraffe, in that situation, you'd be able to evict on that basis. But for the rent issue, again, we're only really talking about the transition time period, again, from September 1 through now June 30th of 2021, where the tenant will have to return the declaration to you if he does, saying that he had an inability to pay because of the virus. Then in that situation, he'd also have to pay the 25%. And that's a substantial amount of money because some of these tenants haven't paid the rent since September. So if we start serving 15-day notices now, he would have to pay 25% of the rent from September through now going into February. My belief is that they won't pay it, and we'll be able to finally rid ourselves of these tenants and get yourself somebody in there who will actually want to pay the rent and act like a responsible person. We're not saying, of course, that there aren't true cases where tenants have lost their job and legitimately can't pay the rent. My experience tells me that most of the people are gaming the system, that they do have the ability to pay the rent, that they haven't lost their job, and they're just using this as an excuse. So the landlord is put into a position where they're having now to finance the pandemic on their shoulders. And even if the tenant is legitimately in a situation where he lost his job, he was working in the healthcare, the restaurant industry or a nail salon. Again, the issue is, yes, the tenant legitimately needs help, but why is that the landlord's responsibility? And that's what we always have to ask our politicians, why the landlords don't just necessarily have to take care of their own family, their own children, but yet they're now having an extended family, which their extended family is called their tenants, that now they have to basically support. So that's basically what the issues are now. We are now extended through June 30th, based on the latest emergency order of our governor in this situation. And so I'm going to encourage everybody that if a tenant does owe rent for the transition period, once again from September through current and extending through June, that we should be serving our 15-day notices at the very minimum. If the tenant does return the declaration and 25% of the rent, well, at least you know that you got some money. And then again, you'd have the right then to bring forth a small claims court action come March 1. If the tenant doesn't pay the 25%, then we have the ability to bring forth an eviction to evict them from the property and get yourself somebody in there who does. The latest thing, and again, this hasn't been finalized yet, so let me talk just a little bit about it, because I really have no idea how this program is going to work. But the landlords are going to be potentially offered a handout from the government to recoup the losses that they sustained as a result of the governmental edict of allowing tenants to basically escape from paying rent. And what we're going to have is potentially the government stepping up and paying the landlord for their lost rent. The landlord would be paid 80% of the lost rent if they agree to waive 20% of the rent. I think that would be I don't know how this program is going to be administered. I don't know when it's going to take place. It's going to be in conjunction with the federal government and the local state. But I think if the landlords have the ability to do that, I'd probably recommend that 80% is better than trying to sue your tenant for that. So if that does become available, then I would probably recommend to my clients, and I have units too where I'm not getting my rent in a certain small percentage, but still, I think that would probably be a good idea to waive 20% of the rent to get the 80%. But as to how this program is going to be administered and when it's finally going to be allowed to happen, I really don't know. It hasn't been set yet. So I know we're probably going to be getting a lot of questions on that, but I don't think anyone has the answers to how that program is going to be administered. But one thing is certain, that why the government should be getting involved in that in the first place, and why we should be told that we can't collect the rents, that's a whole political discussion that I'm happy to engage in, because I don't see that as the role of our government, putting this burden on the shoulders of landlords. So that's basically what's going on currently. I know I've had discussions with this group before, But the latest wrinkle is now that everybody was chomping at the bit come February 1st, that we'd be able to start going forward with a standard 3-day notice to pay rent or quit, at least for the February's rent, and proceed forward with an eviction. That, of course, has now been extended now to the end of June. And so anyone, you're still forced to serve that 15-day notice with the declaration and the information sheet. And of course, the state law. Our firm, of course, can assist you with doing that. We've been doing tons of those. And I know that the floodgates will open in terms of commencing an eviction case come February 1, that at least for those where the tenant either didn't return the declaration or returned the declaration and didn't pay the 25%. So in that situation, we'll be able to go forward, and you'll finally, with a little luck, get your property back. So if we're gonna open it up to questions now, we've got plenty of time to discuss this. So let it rip, but I'm happy to answer any of your questions. Go ahead.
Hi, Dennis. Thank you. When an annual lease expires, how many days does the landlord need to notify the tenant that the landlord wants to terminate the lease? The property is a single-family home. Any difference during COVID regarding this rules?
Right now, in the law, there really is no time that you have to tell your tenant that the lease is terminating and it's not going to be renewed. If you think about it, the lease in and of itself tells you that it's terminated. And if you read like the car forms or any of the realtor leases or my lease, it states specifically that it starts on this date and it ends on this date. A lot of leases will have language in it that says that unless the landlord specifically agrees that that will be the end point of the lease. I recommend, obviously, and you don't serve a 30 or a 60-day notice to terminate a fixed term lease. I would just recommend that you send to the tenant, as soon as you know, a informal letter that basically says, as you know, you signed a lease that states that it's going to be over as of, for example, January 31st, 2021. I am not renewing it, and I do expect you to vacate the premises. But there is no specific time period, though I would do it with as much time as you know to give the tenant a chance to find other accommodations.
Do you serve them? Do you give them a 60-day to move out?
No, it's just an informal letter telling them that your lease terminates on this date and it will not be renewed. That's all.
Thank you.
There's no specific time period. If you don't give any notice whatsoever, the tenant still legally has to move. That's what the terms of the rental agreement are.
So does it also apply to tenants who you lease per room?
Leasing per room would, if you're not in a rent-controlled area, would be the same as well. I mean, you're on a fixed-term lease. Now, if you're in a rent-controlled area, then a lease, even though it states for sure your lease terminates on this date and you must vacate, but under rent control, you need to have good cause to evict. So, for example, in the city of Los Angeles, that lease would just go on as a month-to-month tenancy. It's only for those areas that do not have rent control. So like a single family home or a condo, those types of places.
And this applies to all different counties as well as Riverside, San Bernardino, Orange County?
Yes, it would apply to all of those counties.
Okay. What if you are a buyer and there's no longer an existing lease agreement? I think it's pretty similar. It has expired, located in Los Angeles. Can buyer give tenant a notice to quit? I think it's similar, right?
Well, if you're not subject to rent control, if the tenant's on a month-to-month tenancy, then you would either serve a 30 or a 60-day notice, depending on how long the tenant has occupied the property. If the tenant's on a lease, then even if you sell the property, the lease is still valid. It runs with the land, and therefore the purchaser would have to wait for the lease to expire.
Okay. Properties in city of Montclair for sale and move out notice has been sent to tenant in November 12, 2020, but tenants don't care about it. Esco cannot be closed. How can we do?
Well, if a notice to quit has been served, you would have the right to bring forth an eviction at the end of the notice period. So if it was a 60-day notice, so we would just bring forth an immediate unlawful detainer at this point in time. However, as I say that, I'm thinking, but I believe that the governor extended it now to June 30th. And I presume that also applied to, it was in the AB 3088, it stated that you could evict prior to February 1st. I think based on the latest order of the governor, though I'm not 100% sure because I haven't actually read it yet, I just heard it on the news. I think now that it's now extended to June 30th, that the tenant, you can't ask a tenant to be evicted or vacate prior to June 30th.
Hi, thank you. Hi, Dennis. Thank you. I have a client that just purchased 3-unit complex in Alhambra. The buyer's son wants to occupy one of the unit. Can we evict the existing 20-year tenant who's elderly?
What city property, or did we say?
City of Alhambra, Los Angeles County.
Okay, so Alhambra doesn't have rent control. Is this a single family home?
3 units complex.
Okay, so if it's a 3-unit complex, then if the person is going, if the buyer is going to be moving in as his own principal residence, is that what the question is?
The buyer's son wants to occupy one of the unit. Can we evict the existing 20-year tenant who is an elderly?
Yes, you can certainly do that, even though we're dealing with, quote, statewide rent control. One of the reasons for evicting under statewide rent control is that the owner's son wants to move in. You do have to pay relocation. The relocation would be equal to 1 month's rent. And even though the guy's been there for 20 years, you certainly would have the right to do so.
Thank you. Would AB 3088 apply to commercial lease?
AB 3088 does not apply to any commercial lease.
Okay. On the for rent advertisement, can the language like family preferred be used? I don't believe so, right? You're the expert.
I'm sorry, I didn't hear the question.
There's a question that came in prior. On the for rent advertisement, can the language like quote family prefer be used?
No, if you do that, you're subjecting yourself to discrimination. You're discriminating against old people who wouldn't have a family. You're discriminating against potentially gay people. So I would not use that kind of language at all. That's an open invitation to get sued.
And then on the for rent advertisement, can the language like rent application would be considered after the ad is on the market for 7 days be used?
Technically, under the fair housing rules, and you always want to stay within their guidelines, it's the first application that you received that meets your qualifications. So I think you'd go being awry of that and potentially looking for some sort of a lawsuit against you. So where you're going to just collect, for example, 7 days worth of applications and then go through them, it might be considered discriminatory based on how fair housing considers it. So I would stay away from that concept. And it's the first application that you receive that meets your criteria is the one who you should take.
Thank you. And this is prior to the same person that asked about AB 3088 commercial lease. Is there any rules, guidelines to evict commercial tenants?
If you're in a if there is no local jurisdiction which prohibits it, then you can proceed forward with a commercial eviction. There's a lot of municipalities, for example, LA County, and also the city of Los Angeles, Santa Monica, they do have prohibitions against evicting commercial tenants. I don't believe that's true in Riverside or San Bernardino or Orange County. I don't believe there's any local jurisdiction, so you're somewhat open to do an eviction for commercial at this point in time. AB 3088, the Tenant Relief Act, specifically does not include commercial establishments.
Thank you. And in February, can your company assist with the small claim court for its transition period too? Or they only do the protective period?
No, for both, obviously. They're going to owe 75% of the rent for the transition period. They're going to owe 100% of the rent for the protected period. And remember, this is the game that the politicians are playing, that they're trying to they're just telling you, well, this is deferred rent. Well, we know what they really mean. It means it's free rent on the backs of landlords. And so I would definitely bring forth this action in small claims court, and we are going to try to make it somewhat easy for our clients to basically just fill out an online form. We'll take care of everything else. You will have to show up in court. We'll give you a little checklist approach of how you should address the court and what and how the hearing will go. It's pretty informal, but that's something that we're going to get involved in come next month.
What if tenant did not pay rent prior to March 1st, 2020?
If the tenant didn't pay rent prior to March 1st, that would be the non-transition, non-protected time period, and you can bring forth an unlawful detainer. But your window of doing that is closing so fast. And the reason for that is you can serve a standard 3-day notice for any rent owed prior to the pandemic. Well, the pandemic started March 1 of 2020. Therefore, any rent owed before that, you could serve a standard 3-day notice and move forward with an eviction. But the reason why I'm telling you the window is closing is because in a 3-day notice, you cannot ask for rent more than 1 year old. You cannot ask for rent for more than 1 year old. Well, we're in the month of January right now, which means that the rent owed from February 1st, 2020 is less than 1 year. But I can't ask for rent owed January 1st, 2020, because right now that's more than 1 year old. So the window is closing. So if anybody has a tenant where rent was owed for just February of the year 2020, we can do that case right now. Get on the phone to my office. The phone number's over my right shoulder there. And we can serve a standard 3-day notice for the rent for February of 2020, but that's it, 1 month, and we've got another 5 days. As soon as it hits February 1st, 2021, which is, what is that, Monday? Then that window's closed.
Thank you. Can we serve the termination of lease for a month-to-month tenants?
Again, if you're not under a rent control, either statewide rent control or a local jurisdiction, you can. However, according to the newest order, I believe, and sorry for my indecision, but I didn't actually get the chance to read it because it was just yesterday, but I believe he extended it for all aspects of 3088, AB 3088. So on that basis, you can't actually have the tenant evicted. So you can serve, for example, a 60-day notice now. You just can't get a judgment for the eviction prior to, that's going to be July 1st of the year 2021. So you can start it now. You just got to make sure that you don't get your judgment until June is completed.
Okay, what are the rules applied to the city of Santa Monica multiple family residential tenants, LA County?
Well, they have their own local jurisdiction with regard to their eviction moratorium, which keeps getting extended. It's basically similar to Los Angeles, where if in fact the tenant has in any way, shape, or form indicated that the reason why they're not paying the rent is because of the pandemic, then technically the rent is going to be deferred for 1 year under the Santa Monica rules. So, and basically the landlord can't do anything. You can't serve a 15-day notice. It has nothing to do with transition period or protected period, or even filing a small claims court. You're going to have to wait for theirs to finally be extended. I mean, finally be canceled, and then we can proceed forward.
What if seller did not move out after close of escrow? What could buyer do? How many days notice required?
Okay, first of all, if the seller, where escrow is closed, money has changed hands, the deed's already been recorded, but the seller doesn't move. We see that situation all the time. Number one, this has nothing to do with the pandemic and any legislation. The legislation that exists now deals with protection for tenants. This person in possession is not a tenant. In that situation, and we call that in our office a sale eviction. You sell the property and then you don't leave. So we need to serve on them a 3-day notice to quit and then proceed forward with an eviction. And that's a case that we do in our office all the time. You would think that that wouldn't happen that often, but we see a ton of those cases. I wouldn't in any way, for you realtors out there, I wouldn't in any way get involved with, quote, a lease back situation. If you do a lease back situation, then what you're doing is you're declaring that the seller is now a tenant. And now all of a sudden he's got all the rules relating, all the protections relating to tenants because you did a lease back. He now is a tenant. That's what it is. In those situations, if the tenant, if the seller wants to occupy the properties after the close of escrow, then just put that into the escrow that the seller will be occupying until such and such date and then must vacate. You don't call it rent, have some sort of an escrow credit, call it something, anything other than rent, because we don't want to establish that the seller is in any way a tenant in that situation, which then someone could argue now gains tenants' rights either under a local jurisdiction or under the AB 3088.
Thank you. Dennis, while we're still in emergency period, do you recommend to buy a property with a current tenant living there?
Well, you have to understand what kind of a property you're buying and what the price is. Is it a good price? Because obviously you would prefer to have a vacant unit when you purchase property. But it just really depends on the situation. If it's like a single family home, you should have little problems in terms of evicting the tenant in that situation. But again, it really is a case by case determination. I'll let everybody know, I've had it with the city of Los Angeles. I have an office building in Los Angeles in the San Fernando Valley. And I've just had enough with a guy by the name of Eric Garcetti with the tax involvements. You know, you pay a gross receipts tax here in the city of Los Angeles. So I am now in escrow on an office building, which is about 7 minutes from this building in a wonderful city called Burbank. So I will be making that transition in this year and saying goodbye to my good friend, Eric Garcetti. I'm sure he'll be heartbroken that I'm leaving his city, especially with the tax revenue that he's going to lose. But interesting that I'm buying the building and there is a single tenant in possession of this office building, which is why this story came to mind. But the building is worth it, and I don't think I'll have any problems shedding myself of this tenant, especially since what I do for a living.
Thank you. The tenant owes rent and moved out without notification. Landlord found some damages in the house. Tenant cancel, change all communications, contacts such as cell phone, email, send email and then mail, but the mail returned. Besides the email and phone calls, the landlord also tried many ways, such as posting the letter on the door 3 weeks ago, sending certified mail, and filing it to the police department. The landlord also sent a notice of relief of abandonment on December 14/2020. Current tenants still have some furniture in the house. So questions to you is Mr. Dennis Block. If the landlord can get back the home after 30 days of notice of relief of abandonment.
Okay, well, if you serve a notice of abandonment on real property, you just mail it to the address and the tenant will have 18 days from the date of mailing to send the landlord a statement saying that he has not abandoned the premises, and also an address where he can be served with a lawsuit by certified mail. So if the 18 days has come and gone, then the landlord is free to open the door, change the locks, the place is his. With regard to the abandoned personal property that's left behind, the landlord would have to go through a similar situation where he would send an abandonment of personal property notice to the tenant's last known address, which generally would be your property. At the end of the 18-day period, if the stuff is worth less than $700, then the landlord can dispose of it. If it's worth more, then technically you have to hold an auction where, again, you'd be able to dispose of the belongings. But that is a legal remedy of getting possession of a property, legal possession of the property without going through an actual eviction lawsuit.
Okay, so yeah, this is area that's not rent control and the seller wants to sell it. So I guess the second question was, I think you kind of answered it, need to processing the eviction service. And they
Well, you're
cannot
not going to
contact.
need, I don't think you're going to need an eviction at all, because if you go through the abandonment procedure, then at the end of 18 days, if the tenant hasn't complied, then you have the right to take possession of the premises. Otherwise, you would need to go through the eviction process if he's still there.
Thank you. Does your office service commercial property evictions?
Yes, we do a lot of commercial evictions, doing many cases.
Okay, I think I'm not sure about this one, but it says, hi Dennis, what about San Bernardino, Corona, and Riverside County? I guess they wanted you to touch on a little bit on the law in those
Okay,
counties.
well, those cases all come under the auspices for residential. They all come under the auspices of the state law, AB 3088. So you'd have to serve a 15-day notice and then proceed forward with an eviction. Those areas generally don't have any local eviction moratorium rules, or they don't have any local rent control rules. So it comes under the statewide rent control, AB 1482, for the statewide rent control, and also comes under eviction protection under the Tenant Relief Act, AB 3088. So those are more civilized places. You only have to deal with the state versus having to deal with local municipalities.
Thank you. The tenant is applying for rental assistance from County of Los Angeles COVID-19 rent relief program, but not sure if the government will approve and how much the government will pay. What can landlord do if neither the tenant nor the government does not pay on February 1st?
Well, I mean, again, you can serve, if you don't get the money from the county or now the state, you can serve a 15-day notice. The tenant's going to now have to pay 25% of the rent. If the tenant doesn't pay it in full or return the declaration and pay 25% of the rent, then the landlord has the right to commence an eviction. And eviction courts, for everybody to know, are wide open. We're filing lawsuits, we're getting judgments, we're having tenants locked out by the sheriff's office. You just have to have the right facts.
If I remove a single family home from the rental market through a sale, can we evict?
You can move into your own unit once you become the owner of it. You have to pay, that comes under AB 1482, the statewide rent control. You do have to pay relocation money, which is 1 month's rent. Also, there was under statewide rent control, they had a real easy way of evicting all tenants, which was that you would claim that you're going to be doing renovation. It has to be major renovation that takes at least 30 days to complete and requires a building permit. that was a way of basically getting out of most properties that where rents were low and you wouldn't have a ground to evict under statewide rent control. That reason has been suspended. It was suspended until February 1, and now it's going to be suspended until July 1, where if you do have a tenant and you with low rent and you want to evict, then that would be a wonderful way to evict them based on that you're going to do renovation to the unit. If the tenant is paying low rent, then when the tenant vacates, you're going to have to do some renovation to the unit anyway. It makes sense if you want to get top dollar. So it's a pretty simple way, once this pandemic is behind us, God be willing, that we will be able to get out of the onerous of statewide rent control by using the renovation reason.
Does AB 3088 apply to commercial property in Los Angeles County?
AB 38, once again, does not apply to any commercial property. I don't care where it's located.
Thank you. Can a family that purchased a home in San Bernardino do no cost eviction since they gave the tenant 3 months to find a new home after close of Esco?
If your property is not subject to statewide rent control, and a single family home would not be, then no relocation money is required. You just serve the proper notice with the reason, and you have to state the reason properly in the notice, but assuming you do, then the tenant does have to vacate.
The city of Covina has rent control for 5-unit and 11-unit apartments.
The city of which, please?
Covina, I'm sorry.
Is that a question?
I
Or
guess.
is it a statement? I'm not aware of Covina having rent control. It could, maybe they just passed it, but I'm not aware of that. I would think it would come under statewide rent control.
City of Commerce incorporated in Los Angeles County. Commercial tenants receive 30-day notice to vacate. They need more time to find another location and move. Are there currently legal ways to stay longer, even though the landlord is only giving 30-day notice?
Well, in the county of Los Angeles, there's still a moratorium on commercial tenancies for just terminating their tenancies. So you're going to have to wait at least until the county ends it. The county is currently is statute is up as of February 28th of 2021, coming up in about a month. But you know, and I know that they'll extend that, and they have the right to extend it to at least till the end of June.
Can you disallow emotional support animal? Tenant has month-to-month lease and then wants emotional support animal.
If the tenant has a letter from a medical professional that indicates that the tenant has a disability and needs the services of a comfort animal, then the landlord must allow that. If he doesn't, then he can get sued.
You got a default judgment early December against tenant. The Los Angeles City Court is supposed to finalize in their system so you can notify sheriff for lockout. Does this new ruling by CDC affect my lockout? My case was not related to COVID.
No, the CDC doesn't affect cases in California, is our position. We've had some judges disagree with me on that, but most judges are, and my understanding of the law is CDC doesn't apply because California has its own eviction moratorium.
Thank you. What are the rules applied to City of Santa Monica for multiple family residential tenants in LA County?
I mean, that's kind of an open-ended question. I mean, they have their eviction moratorium rules, and obviously they have very strict rent control for reasons for eviction in Santa Monica. So
for seller eviction, seller holds over for 6 months and finally move out last August. Can I file a small claim court now?
yes, absolutely. The rental value of the property is what the landlord, what the purchaser lost. And you could definitely bring forth a small claims court. If you do, you're limited to $10,000. If we're talking about rent during the transition period or the protective period, as of March 1, coming up in about a month, the jurisdictional limit is open-ended for small claims court. But for that, and it would seem like it would be more than $10,000, the person might want to file a regular civil lawsuit.
Thank you. I believe you mentioned this as well. If my tenant only pays 25% during transition period, which date that the landlord allowed to request the balance of 75%?
Technically, it's owed as of February 1st, unless this new law changed, unless the governor's order yesterday changed it, but I don't think it did. So it would all be owed on February 1st. You could make a demand for it. If the tenant doesn't, then you have to wait until March 1 before filing suit.
What if original owner's tenant stayed after auction but can issue sale of eviction too?
When you say an auction, in other words, what I'm guessing is that there was a foreclosure sale. I'm guessing that that's a foreclosure sale. The issue is if there is a foreclosure sale, then the tenant is required to vacate, but he has to be served a proper notice. If in fact the property is under rent control, let's pretend it's a duplex and it's under rent control, then you're going to have a reason to evict.
Thank you. Would the rent be increased at this point? They were referring to San Bernardino County. I'm not sure about that question.
Yes, you're allowed. Nothing prevents landlords from raising the rent. In the city of Los Angeles, for example, they have a moratorium on raising rents for a year. But other than that, you are allowed to raise the rent. If your property is not subject to rent control, even in the city of Los Angeles, you can raise the rent to whatever level you want. If your property is subject to statewide rent control, it's 5% plus the current CPI as promulgated as of April of each year. I don't know what it is for Riverside or San Bernardino, but I do know for Los Angeles County, the CPI was 0.7%. Therefore, you're allowed, if your property is subject to statewide rent control, you are allowed to raise your rents right now, today, 5.7%.
Thank you. There's a lot of questions. What if the property was bought to be rented out, but not to seller, but to be rented to somebody else? Can you evict the seller after close of escrow? It's not going to be owner occupied.
If your property is not under rent control, you can always ask the tenant to vacate. If your property is subject to rent control, you're going to have a reason as enumerated. If it's under state law, the state law reasons. Again, you could always use the renovation one, assuming the work needs to be done in the unit.
So after giving 15-day notice, tenant did not reply. Eviction process can start on February 1st, 2021, but cannot file at civil court to get back the money owed until July 1st, 2021?
You can file a civil lawsuit for the money as of March 1, 2021, under the law.
Says Dennis, you told me we can't evict commercial tenants in the city of Los Angeles. So for the city of Los Angeles, can we evict commercial tenants?
That comes under the auspices, again, of our wonderful mayor, who has put forth open-ended protection for both commercial and residential tenants. So you can't serve a 3-day notice for the rent until finally the mayor of the city of Los Angeles states that the emergency period is over.
That's all the questions we have. Thank you so much, Mr. Block.
Thank you. It was very nice talking with you guys. I always enjoy it, Mindy.
Thank you so much.
Have a good day, everybody.
Pauline, back to you. Thank you.
Thank you so much. What a wonderful section. Thank you, Mindy and Mr. Block. And we definitely learned a lot this morning. On behalf of West and Gabriel Valley Realtors, we would like to thank Mr. Dennis Block for your wonderful presentation today. Please contact his office directly if you have any further questions. A quick reminder for next few classes. Next Tuesday, February 2nd at 10 a.m., 2021 Pandemic Feng Shui Setting by Feng Shui Master Alex Z. And for February 8th, Monday at 11 o'clock, Attorney Paul Horn will come to talk about current Proposition 19, how it affects the homeowner property taxes. And very important, please save a date for February 10th at 11 o'clock Wednesday, 2021 Real Estate Outlook. We invite Mr. Oscar Wei from CAR, Senior Economist, to give us a speech. Please register all the classes online at wsgvar.com and choose a class and class schedule. And we hope you join all the classes and learn together. Thank you, Mr. Block, Mindy, Fang, and all of you. And we wish all of you have a very successful 2021. We see you next Tuesday at 10. Thank you so much. Bye-bye.